I don't know what else to do. I don't know how this is going. My attorney is sitting here telling me something about an argument. This is the only thing that is holding me up. If you notice, I didn't have any prior violations while on probation. It's been 8 months and I'm not successful. I've never been successful on probation. I just brought up the fact that my due process was violated, and then violating this due process, they were still waiting for a victim or a witness who never showed, Your Honor.
Okay, if you're objecting, here's what we're gonna do. No, here's what we're gonna do. I'm gonna adjourn it to tomorrow over the defendant's objection. You can file a new information, start over. He doesn't get any credit for the time that he's been in. That's how we're gonna do it. I'm done. You can't keep talking to me on this. What does call the case of the People versus Patrick Bernard Thorns. Counsel, state your appearances, please.
Ready.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
On Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patrick Thorns. Mr. Thorns, state your name.
How you doing, Mr. Senator? Patrick Thorns here on behalf of Patrick Thorns.
Okay, thank you. Date and time set for a preliminary examination. Are the parties ready to proceed?
Yes, Your Honor, we are ready to proceed.
Call your first witness.
We're ready to proceed.
Your Honor, last week,
Okay, what do you want?
how you doing today, bro?
I'm great, thank you.
I was arraigned on the 29th of December, I believe, 28th.
What?
I was arraigned on the 28th and 29th of December. Last time I seen you, we had an argument, I believe, Miss Courtroom, I'm sorry, with my public defender.
Mm-hmm.
You see that was held on me left. Wesley, I just had a couple of things that I noticed when I went to the law library. I'd like to state on the record. The prosecution had for a 2-week adjournment outside of the 12-day preliminary examination. Oh my God, I'm sure. Weston Remedy, MCL 7.66. I believe that you can get in contact with the victim and order to get in contact with the witness. It was supposed to be scheduled for the 16th, on the 23rd, we got an adjournment because the weapon. But I was outside of my 12-day preliminary examination and
Okay, so I'll tell you what we can do. If you want to do it this way, we can do that. I'll set it for tomorrow. I'll just have the people prepare new information.
No, it's fine. I just wanted to see if that information was correct, sir.
If what information was correct?
My attorney was aware of this. I didn't know, but there was supposed to be a victim in this matter. This is a hearsay matter. We can proceed. I just wanted it to be stated on the record. That's all I heard.
So are you objecting to the timelines? Because I'm not going to go ahead. I mean, I don't know that the adjournment that was originally asked for was asked for by the people. I have it attributable to the defendant.
No.
I think Ms. Coons asked for the adjournment when it was
No, sir. She asked for the 16th. We gave her the 23rd because the prosecution stood and wanted to bring in witness, right?
That would have been on 5 days. That's why. And then it was, so I set it for the next available date, which was the 23rd.
Also, yes, storm.
And that the court would find was good cause to adjourn the proceedings. No court proceedings were going on those days. The court was closed.
So it's okay. I wanted to make sure that it was understood that I was arraigned on the 28th or the 29th and that 12-day ruling.
Okay, Mr. Thorns, let me just tell you. Are you objecting to it? Because I will make a full record as to why it is set in this way.
And for the record, I have explained all of this things, so I've made it clear to him that either.
We can proceed, man. If you're going to just go ahead, we're gonna just do whatever. Go ahead. I know that it was adjourned because the prosecution wanted a later date. But they can get
There were 2 dates. You couldn't do it in 5. I gave the next date, which was within the time limits. Did that,
a whole nother.
and then it was 12 days.
outside of it.
Okay, if you're objecting, here's what we're gonna do. No, here's what we're gonna do. I'm gonna adjourn it to tomorrow over the defendant's objection. You can file a new information, it starts over. He doesn't get any credit for the time that he's been in. That's how we're gonna do it. I'm done. You can't keep talking to me on this. So this is adjourned to tomorrow at, I'll adjourn it. Yeah, I'll adjourn it to tomorrow, special time. You can have a new case prepared.
I will make some calls tonight and make sure that happens.
Examination.
Yeah.
Is it possible to have it in the afternoon, Your Honor, just so?
We'll set it in the afternoon. Okay. 1 p.m. And I apologize to the witnesses. They did not know this was going to be raised. So preliminary examinations adjourned one day to January 31st, 2024, 1 p.m. to rule on defendant's motion, which was raised orally.
Procedurally, yesterday.
I did not dismiss it. I didn't rule on this motion. I'm going to rule on it today.
So we just did a reauthorization.
Correct.
Which should be classified.
This proceeding? Yeah, the first thing procedurally I'm going to do is this. Court does call the case of the People's State of Michigan versus Patrick Bernard Thorns, that being case 23F2-1724.
Getting Attorney Morgan Barroso on behalf of the people.
We're ready in this now. One round down.
Patrick Thorns here on behalf of Patrick Thorns, sir.
All right. On this matter, yesterday, Mr. Thorns raised the issue of whether or not the statutory guidelines regarding his preliminary examination timelines regarding the PCC and preliminary examination, that whether the case without a waiver had extended beyond that. I'd indicated at that time that it was my belief that on whether it was January 11th, when the exam was set for this date, that there was indeed a request by the defense to adjourn and no objection to the setting of the date. Although the CARO, or the Register of Actions, does not reflect that, out of an abundance of caution, I indicated yesterday that I would look at it, see what I could determine, and then rule on the matter today. I'm still unable to determine that. So in order to protect the defendant's rights, taking what he raised as a motion, the court will grant his motion and dismiss this case. I will then show that case is dismissed. Since Mr. Thorns is here, I will arraign Mr. Thorns on a new complaint, which has been authorized against Mr. Thorns. Mr. Thorns, you are before the court on the charge of domestic violence third. This is alleged to have occurred on November 30th, 2023 at the location of 454 South Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan, event against a Zakia Graham. That complaint specifically alleges that on that date and at that location, you did make an assault or an assault and battery upon Zakia Graham, an individual with whom you had a dating relationship contrary to Michigan statutes. You understand that, sir? The complaint further alleges that this would normally be a misdemeanor offense. However, this is charged as a domestic violence third, indicating that you had been previously convicted of domestic violence on or about February 20th, 2008, and also on March 5th, 2008. And I don't have the court location, but that you had previously been convicted of that same offense on those dates. You understand that, sir? That makes this a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. First question I have for you, Mr. Graham, is do you wish to be represented by an attorney?
Yes, sir.
This is a public defender case. Mr. Brown.
Thank you, Your Honor. I represent Mr. Boyce.
All right. As to the new complaint, you waive any further formal reading?
Yes, Your Honor, we waive formal reading of the complaint. My client will enter a plea of not guilty at this time.
All right. Defendant pleading not guilty. Court will enter that plea. I will then set this matter after setting bond on this case. I would indicate this one. 100,000 cash surety.
Yes.
I will set the defendant's bond at the previous amount that was set. I will set it at $100,000 cash surety. I would indicate that you are to report if you are released to community corrections for drug testing. There should be no use or possession of any alcohol, marijuana, or any illegal drugs. You are not to leave the state of Michigan without permission of the court. You are not to possess or purchase a firearm, ammunition, weapon, or anything designed to be a weapon, or any other dangerous instrument. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are to have no contact with Zakiya Graham, except with civil standby with the police. You are not to leave, or you are not to have or attempt to have any direct or indirect contact with that named individual, in person, through others, by electronic communication, including but not limited to phone, email, texting, internet, or social media. Do you understand that, sir?
Yes.
You are not to go to the location of Ponderosa Court in the city of Ypsilanti, except with a civil standby with the police. If this is your home address, you must find another place to live or notify the court with the new address within 24 hours, of your release from jail by contacting the court. You are not to violate any criminal law of the state of Michigan or any other state. You understand that, sir?
Yes.
All right.
Your Honor, my client would like to be heard on the issue of bond.
Go ahead.
Now, the bond is set at $100,000 cash assured. It's based mainly on allegations of an assault. The first thing we'd like to point out is my client maintains his innocence in these matters. Second, the prior convictions used to put this to the felony are from 2008. That is 16 years prior to this. We're asking the bond be set at a more reasonable amount. My client will obey all orders of the court to have no contact. He will return to all future court dates.
Anything from the people?
Yes, Your Honor, the only thing I would like to highlight is that at the time of this offense, he was on felony probation for a controlled substance as well as a felony weapons conviction. At this time, we don't think any modification of the bond is appropriate. In fact, I would like to add, if he is able to be released, we would be requesting a GPS tether in hot zones for Ms. Graham's address.
Your Honor, may I state that on the record, the prosecution had ample enough opportunity to get in contact with this witness. I'm sure that they've gotten in contact with this witness and his victim. There's no intention on this witness or victim coming. Like I said, I don't know what else to do. I don't know how this is going. My attorney is sitting here telling me something about an argument. This is the only thing that is holding me up. If you notice, I didn't have any prior violations while on probation. It's been 8 months and I'm not successful. I've never been successful on probation. I'm sure that they did get in contact with the victim. They were going to bring a police officer in here and try to state what we would call on the basis of truthfulness and trustworthiness. You know? I just brought up the fact that my due process was violated, and in violating this due process, they were still waiting for a victim or a witness who never showed, Your Honor.
All right. I'm gonna. Defendant's bond is on the previous case in the amount of $100,000 cash surety with the conditions that I have. I will set this matter for PCC
That's the next one.
That's the next one.
Yes.
Set probable cause for February. Well, why don't we do both?
12.
Let's do both days. I got to set a PCC, so he was at PE, so it's got to be set before me. So we have 21 days, so we don't have the same issue. So the 20th.
Yes.
I'll give you 2 dates. Probable cause conference will be set February 8th, 2024, 9 a.m. I will also at this time set a preliminary examination for February 20th, 2024 at 9 a.m. in person. That is before me.
Thank you.
And that's where today's story comes to an end. If you enjoyed this incredible journey filled with unexpected twists, emotional moments, and unforgettable characters, don't forget to leave a like. It really helps the channel grow and lets us know you're enjoying these stories. Be sure to subscribe and turn on the notification bell so you never miss our next upload. We bring you new stories packed with drama, suspense, romance, and life-changing surprises on a regular basis. Now we'd love to hear from you. Which moment surprised you the most? Who was your favorite character? And what would you have done if you were in their place? Share your thoughts in the comments below. We read as many of them as we can. Thank you so much for watching and spending your time with us today. Your support means more than you know, and we're excited to bring you even more amazing stories very soon. Until next time, stay safe, stay kind, and keep believing that every story has the power to inspire. See you in the next video.